Hey everybody, my name is Shaunak Darup. I'm a partner at Arns Davis Law in San Francisco, and today I'm going to talk to you about the one thing that litigious whales and abortion pill access have in common, and that is standing. Standing is a technical requirement for bringing a lawsuit, and it's baked into the Constitution. We're going to talk about that, and we're going to talk about some of the implications of standing, what it means for who's even allowed to bring a lawsuit, or what is allowed to bring a lawsuit, and what that means for AI and ChatGPT suing you in court. And then I'm going to talk about the recent Supreme Court decision in FDA versus Alliance for Hippocratic Medicine, in which the court basically protected access to this abortion pill, mifepristone. Article 3 of the Constitution talks about the judicial branch, and it talks about how the role of the courts is to adjudicate cases or controversies. That's the language that's used in the Constitution, cases or controversies. That language has been interpreted by courts to mean a couple of very specific things, mostly requirements to even bring a suit in court. It basically lays out the jurisdictional bounds of what the judicial branch is allowed to preside over. The cases and controversies requirement includes a requirement for standing. Standing means that you have to have suffered an injury in fact. You have to have been actually harmed, and that injury has to be redressable. That means the court has to be able to fashion some sort of relief to address that injury. One of the issues that's related to standing is the political questions doctrine, which is there are some questions that the court will say, this is outside of our lane, not a controversy that needs adjudicating under the law, but a question about what the law should be, or a question about what the executive should do. And so those are questions that are best left for the other two branches of government and not us. Another requirement is that the issue can't be moot. The mootness doctrine means that if the harm has been fixed, or if the controversy no longer exists by the time the court comes to adjudicate over that dispute, well, there's no more dispute and the harm's been reversed. And so it's really not something that the court can address. And so there are times when a case will be moot and the court just will say, we don't have the power to adjudicate anything because there's no harm here. Now, there are exceptions to mootness, and one of them is if there is a harm that is capable of a repetition and evading review. So one really great example of this is the Roe v. Wade case, because by the time that case made it to the Supreme Court, the baby at issue had already been born. And so that was not something that a ruling by the Supreme Court could change, except it met that requirement of a harm that was capable of repetition and evading review. In simple terms, this means because the issue in the case was basically whether the right to terminate a pregnancy lies with an individual and not the government, that there's a fundamental right to terminate a pregnancy through abortion. It's a condition, pregnancy, that is repeatable, and yet one that would continue to evade review. Over the 9-month period of pregnancy, by the time a woman who would need an abortion or want an abortion would try and get one and be denied it, the case would never be able to make it through the court system to get a ruling on it, because of the timeline these things take. And so it would continue to evade review, even though it's a repeatable harm. So that's an exception to the mootness doctrine. Another doctrine within the cases or controversies requirement is ripeness, which is sort of the opposite of mootness. Ripeness means that the controversy actually has to be ripe. It has to be ready for adjudication in order for the court to adjudicate it. So the court can't be sort of giving advisory opinions or looking in the future at a harm that might occur. The ripeness doctrine is a limit on a court's authority to interpret the law. Even though we're in a common law system and courts are tasked with interpreting the law and creating precedent that shapes the law, there is a clear distinction between the role of the courts and the role of the legislature to make the laws. And if we didn't have the ripeness doctrine, and courts were able to give advisory opinions about future factual scenarios about what could arise under the law and create precedent in that way, then it would really be usurping the role of the legislature, which is to create laws to protect against future harm. One of my favorite cases to illustrate the concept of standing involves a case in which all of the whales, porpoises, and dolphins in the world sued the US government. Yeah, every single cetacean in the world sued the US government. And the way they did it was through a lawyer who appointed himself as their lawyer and sued on their behalf. And the facts at issue were really a sonar system that the US Navy was testing, and the plaintiff, dolphins, whales, and porpoises, alleged that it was causing them physical harm. Now, they sued under specific environmental protection laws, which were federal statutes created by Congress. And the first question for the court was, do all the whales, dolphins, and porpoises in the world have constitutional standing to sue the U.S. government? And the answer was yes. They have standing under the U.S. Constitution because they allege they suffered injury in fact, that the conduct of the U.S. Navy was actually causing them physical injury. And there was redressability because they were seeking some specific remedies from the government, including having the government stop what they were doing. It was an actual controversy, Article 3 standing. Now, it's generally the case that when we're talking about complex legal issues of first impression, the sea-dwelling mammals are usually really ahead of the game on it. And so it wasn't until a few years later that the primates got a wind of this decision, and there was a case in which a monkey took a selfie and then tried to sue to get a copyright to the image. And the same question arose in that court. Does the monkey have Article 3 standing? And the question here was slightly different because in the cetacean case, the whales and porpoises and dolphins had alleged physical injury. In this case, the monkey was alleging economic harm, the right to the copyright, so the monkey could license it and make money off of it. In the cetacean case, the Ninth Circuit made the point that it's always been allowed for non-persons to sue under Article 3. For example, people can bring lawsuits standing in the shoes of organizations. And so the Ninth Circuit didn't think that the fact that a dolphin or a whale or a porpoise or a monkey wasn't a person was any barrier to Article 3 standing, and in fact said as much, that Article 3 of the Constitution doesn't require that the entity bringing the lawsuit is a person. All it requires is that injury in fact, causation, and redressability. So why isn't it the case that every animal that's mistreated is suing for animal rights abuse and winning in court? Well, because it's a little misleading to say that they have standing. It is true they have Article 3 standing, or they can have Article 3 standing, but Article 3 standing is like the bare minimum jurisdictional requirement under the Constitution for the courts to even be allowed to exercise their authority. It's the floor. You have to meet this to even get into the courts. But what you also need is you need standing under the law that you're suing under. So in both the cetacean and the copyright monkey case, the laws that they were suing under did not confer those animals with standing. The court held in the cetacean case that, yeah, there was Article 3 standing, but the federal statutes under which the whales, dolphins, and porpoises were suing the federal government did not allow them to have standing to sue because they required that a person, not an animal, be the one bringing the lawsuit. Similarly, in the monkey case, U.S. copyright law didn't allow non-persons to hold copyrights. And so the monkey didn't have standing to bring the lawsuit under the law that he was seeking redress under. So there's constitutional standing under Article 3, the bare floor, and then there's also standing under the specific law through which you're seeking relief. What does this mean? Well, it means that while those laws didn't allow the animal plaintiffs to have standing, because there's no constitutional bar to Article 3 standing, it is possible for Congress to enact a law at some point in the future that would allow animals to have standing to sue. There would be no constitutional barrier preventing that. All that would prevent that is the creativity and the will of our congressional leaders. There are countries that have given personhood rights to rivers, for example, or other animals. So it's not inconceivable. It's just not something that's been done yet. It does bring up the question of what happens as generative AI becomes more and more able to replicate a person. At what point will ChatGPT be able to sue? Will we ever reach that point? And when this goes before the courts, how will the courts rule on the question of Article 3 standing for an artificial intelligence? Now, bringing this back from the slightly speculative and silly to the very serious and the implications on people's fundamental rights, a question before the Supreme Court recently was whether to preserve access to an abortion pill that was approved by the FDA back in 2000, mifepristone. The FDA took some regulatory steps to make it easier for people to get access to the medication. It's a medication that assists in terminating a pregnancy. Now, the plaintiffs in this case were doctors and medical associations who had moral issue with the concept of abortion, and they sued the FDA because of the FDA's actions to make the drug easier to access. Writing for the majority, Justice Kavanaugh wrote that the plaintiffs didn't have standing. The doctors who had brought the lawsuit hadn't actually been harmed because no one was forcing them to prescribe the drug. Federal law already says that doctors can't be forced to prescribe this medication. They can't be forced to provide an abortion. And so there was no allegation from the doctors that they were being forced to prescribe this in any way. The argument the plaintiffs made was that there are downstream consequences from the FDA's actions that directly harmed them. And the actions were, well, if you make this drug more widely available and easier to get, people will take it, and then they may suffer complications from taking the drug, which means they'll come to us and we will have to treat them. It will create an extra burden on us. It'll increase costs, potentially increase, medical malpractice liability. It'll have huge effects because it'll increase the burden on the healthcare system in general. It'll increase health insurance costs. All of these downstream consequences that really are so attenuated. And the court found as much, that the doctors couldn't credibly argue that they were actually being harmed by the FDA making it easier for people to get this drug. Well, then there were some medical associations that were plaintiffs, and they said, well, the FDA's actions have made it so we've had to commission studies to find out how harmful this drug can be. We've had to pay a lot of money to educate people about why they shouldn't be taking this drug. We've had to spend a ton of money just to counteract what the FDA has done. And the court said, no. You spending money and diverting your own resources in response to the actions of the defendant, that's not enough to confer standing. That's not actually injury in fact within the meaning of Article 3. You don't have constitutional standing. The other thing that the court said was, those issues that you have with this drug are better brought to your regulators and your legislators. Don't bother us in the judicial branch about the way the FDA promulgated its regulations or changed the way that this drug was accessed. Go talk to your congressperson. Go talk to your president. That's an example of the court avoiding a political question, saying, hey, that's an issue that's better left for the other branches of government. Now, a word of caution. It's really easy to get swept up in the way that Supreme Court decisions are publicized. And the way that the Supreme Court decision has been publicized all over the media is that the Supreme Court unanimously protected access to abortion pill. Technically, sure, but that's not really what happened. That creates this false idea that the Supreme Court has taken some sort of ideological step and put its foot in the ground and said, no, people should have the right to access this abortion pill. That's not what the court did. I mean, this is the same court that overturned Roe versus Wade. This is not the court that is making an ideological decision to protect abortion rights in any form. What the court did was it simply found there was no standing. A hyper-technical, jurisdictional question. Is it important and impactful? Absolutely. But it's really important to remember that when you're reading these Supreme Court decisions or reading the headlines about them, everything does not fall down on ideological lines. And the danger is that it can create some amount of complacency in people's activism in democracy. If you support bodily autonomy and abortion rights, and you see this decision, or at least the headlines around this decision, you may be led to think the Supreme Court has taken this step to protect these rights, which is not what's happened. And because of that, it's possible you may be a little more complacent in advocating for your position in the democratic way that people do, by writing to their congressional leaders, by participating in elections. You may feel that the court has taken a step to protect a right that is very important to you, and so you may then dial down your activism in that area. And it happens all the time where we see Supreme Court decisions and the media labels them in a little bit of clickbaity headlines, and people feel like the court is taking stances one way or the other, when many of the opinions come down on very technical and procedural lines. Now, that isn't to say that the Supreme Court justices aren't overlaying their ideologies on decisions. You'll see that the big hot button social issues that come up in Supreme Court decisions often come down on ideological lines, conservative and progressive. So I think two takeaways from this video. The first is it's only a matter of time before the whales, the monkeys, and AI file a lawsuit against you. So be careful about what you're saying to ChatGPT. And the second is be careful when you're reading headlines about Supreme Court decisions, because a lot of times they come down on these really fundamental, technical, nuanced issues, which are really important to know, I think, and very interesting to learn about, but are not the broad, sweeping, fundamental right decisions that sometimes the media paints them as. So I hope you have enjoyed learning a little more about standing, which I think is a super interesting topic, but then again, that's because this is my job and I'm a huge nerd. Enjoy the rest of your day, and I'll see you next time.